Counsel, given what you said about the right to control as, whatever you want to say, properly understood, or, the Second Circuit has gotten a bum rap, but there's something here. We should go on and decide the question presented, which is whether or not the right to control theory is valid, right?
Yeah, I agree that the court should obviously decide the question presented. I would urge the court that in doing so, I guess I would say a couple of things about that. First, as we explain in our brief, we think the right to control theory properly cabined and, as it was applied in this case, does identify cases that are traditional property fraud. And I can get to why I think this particular conviction should be affirmed under the doctrine in a second. But I take great issue with the idea that cases like this are categorically out of the scope of property fraud, which again, I don't really see much difference between this and a veterans contracting preference benefits type case, where there's just a misrepresentation, not about the services you're going to receive, not about how good they are, not about the price you're getting, but about the fact that somebody who owns a business is in fact a veteran of this nation's armed forces.
Counsel, you said that you think the theory is still valid, properly cabined. Was the theory properly cabined in the jury instructions?
Your Honor, I think if you took the jury instructions outside the context of this case, the jury instructions encapsulate a view of the right to control theory that could, in some cases, lead to overbroad results. However, the jury received a copy of the indictment in this case. If you look at Joint Appendix 27, paragraph 14 of the indictment, it makes clear that what the goal of the scheme here was exactly what I said at the beginning, which was to get $750 million in government funds by rigging the bidding process and lying about it. And
so the theory would be properly cabined because the jury would, of course, not simply rely on the instructions, but also read the indictment and would properly resolve any difference between the two.
Well, Your Honor, I think the instructions told the jury that it had to find that the property here was the right to control assets. And I think in certain cases, the jury also had to find tangible harm. And I think that perhaps in certain cases, even that might still go too far. But in the context of nearly every fraudulent inducement case, and certainly in this case, what the jury's going to find when it finds that the property was aimed at the use of control of assets in the context of two parties that are bargaining for a contract, the assets are going to be the contract funds. And then what you have is a species of fraud that has long existed at common law. Again, I take them to acknowledge the horse of a different name case, where what you want is a horse named James and you get a horse named Henry. But it also covers cases of pedigree fraud. I think the best examples are